So our first speaker is going to be Robert Vega. Robert is a senior policy advisor at the U.S. Conference of Catholic Bishops, where he serves on the subcommittee for the promotion of marriage. Robert is a graduate of Harvard Law School. He spent nearly a decade working, and I first got to know Robert on the St. Joseph's softball team. The Act would mean the impact it would have on Catholic institutions, such as Catholic charities, and how the public accommodation law intersects there. So Robert, over to you.
Thank you, Ryan. And thank you also to the host dioceses and state conferences for this evening's event, and good evening, everyone. I will be talking about the impact of the Equality Act on various faith-based services from the perspective of the U.S. Conference of Catholic Bishops, as well as a little bit about the broader shape of the bill. But I'd like to start with the words of Pope Francis in his 2016 Apostolic Exhortation, Amoris Laetitia, in which he wrote, quote, "Biological sex and the sociocultural role of sex, gender, can be distinguished but not separated." He continues, "It is one thing to be understanding of human weakness and the complexities of life, and another to accept ideologies that attempt to sunder what are inseparable aspects of reality." End quote. As you all know, the Catholic Church provides a vast universe of services in charities, schools, healthcare, and more. In 2020, Catholic charities alone, which is just one piece of the puzzle and second to only the US government, helped 13 million people with disaster relief, shelter, food, wellness, including addiction recovery, asylum, employment readiness, and more. In all this, I must stress Catholic organizations serve all beneficiaries and do not deny or discriminate against any for identifying as LGBT. The Equality Act, however, would mandate how we serve others in ways that force us to either violate our faith or shut down, both of which are worse for the beneficiaries. Before getting to how it does so, we should consider a couple key sections of the bill. Section 3 deals with what is called public accommodations in the Civil Rights Act of 1964, which forbids discrimination on the basis of race, color, national origin, and religion in gas stations, theaters, restaurants, and hotels. The Equality Act takes this and does two things. First, it greatly expands the types of entities covered to now include any place of public gathering and any establishment that provides a good service or program. So virtually every consumer or charitable place or service. That would include hospitals, gyms, wedding vendors, shelters, and some argue it may even include houses of worship, religious funeral homes, and private schools. Section 3 also adds the category of sex to those that cannot be discriminated against in public accommodations. But because of the new definition of sex in Section 9 of the bill, this now includes also sexual orientation, gender identity, and various terms related to pregnancy. Now, if this were understood to simply protect someone from being denied service at a restaurant or hospital because they identify as LGBT, that may be one thing. But language like is in the Equality Act gets taken much farther than that. And as we'll see, requires others to speak or act in support of gender identities that differ from sex, and also same-sex relationships, and it overrides existing sex-separated facilities and programs. Importantly, it does not limit its reach to those with gender dysphoria, but allows anyone else to self-identify in any way at any time. Section 6 is another major section and does similarly in regulating every program or activity that receives federal funding. That would cover countless charitable organizations, health providers that take Medicare and Medicaid, schools, and other entities that partner with the federal government for the common good. So, in terms of effects under the Act, Catholic foster care and adoption, for example, would be forced to place with same-sex couples, which violates children's rights to a married mother and father, or be shut down. And we have seen this happen in several jurisdictions with similar laws. Shelters, which often protect particularly vulnerable women, would be forced to make them share sleeping and showering quarters with biological men. Again, this concern isn't about turning anyone away. It's about flexibility in how to make arrangements that are best for ensuring that everyone has a place to sleep in which they feel safe. Other social service programs, like support groups for women in crisis situations, would likewise be opened to males under the Act. Even halls attached to houses of worship, if they ever open their doors for food service to the homeless, which many do, would be forced to allow restroom access to the opposite sex, again, among vulnerable populations. And church grounds open to community events could be made to host events that conflict with their faith. In healthcare, Catholic doctors and hospitals, who will of course provide healing and life-saving care to everyone, regardless of characteristics, would now be mandated to perform gender transition procedures. And counselors would have to affirm transition rather than acceptance of one's body. At least 5 Catholic health entities have already been caught up in lawsuits under similar laws. But that's not just bad for their conscience rights, but given the increasing rate of young people experiencing gender dysphoria and the historic rates of kids otherwise resolving it with age, it's problematic to legally say to adolescents going through this pain that there are no options other than life-altering procedures anymore, as this bill does. There are also abortion mandate concerns, which Dr. Girgis will address later. In Catholic schools, all of our universities, on account of accepting students who need federal aid, and potentially at least half of our 6,000 K-12 schools, depending on whether judged to be recipients of federal funds through student lunch or such generally beneficial programming, or on the extent of the new public accommodations expansion, they would have to align sports teams, locker rooms, dorms, sleepover field trips, and speech with gender identity. Single-sex schools might be completely out of the question. State school choice programs linked to federal discrimination law could cut out our Catholic schools. And even any schools that could maintain sports teams based on sex would still have to compete with other school teams that can't. And it's worth keeping in mind the opportunities that Catholic schools bring to kids in communities with underperforming public schools. As a side note, you may hear that the Equality Act does not touch Title IX, which famously dealt with women's sports in school. While that's technically true, the bill's amendments to the Civil Rights Act, Title VI, override that and lack all of the nuances for religion and sex-separate programming that Title IX has. You may also hear that states with similar laws have not created problems. Well, from various examples, we maintain that in many cases they have. But also, it's notable that most state laws have religious protections. The Equality Act diminishes existing religious protections. And lastly, in all of these contexts that I've discussed, no Catholic organization that hires non-Catholics is exempt under Section 7 of the bill from having to hire and retain employees who publicly contradict the faith with their sexuality-related conduct, or from having to treat them as the opposite sex in speech and facilities, or having to cover abortions, contraception, or gender transition procedures in their health plans. So you can imagine another iteration of the Little Sisters of the Poor saga, and multiplied by quite a bit.